Then we have to see several cases which we have to discuss, and we will discuss this as and when required. That is Barendra Kumar Ghosh versus Emperor. We have seen that is commonly known as the postmaster murder case. Then Mehboob Shah versus Emperor, popularly known as the Indus River case. Then Ramnath versus State of Madhya Pradesh, AIR 1953, Supreme Court cases, page number 420. Then Pandurang versus State of Hyderabad, AIR 1955, Supreme Court, page number 216. Then Kripal versus State of UP and others. Another case where in the scope of liability under section 34 of the Indian Penal Code or section 3 subsection 5 of Bharatiya Nyaya Samhita was discussed is Mehboob Shah versus Emperor, a very important case popularly known as the Indus River case. The brief fact of the case is on August 25, 1943, at about sunrise, one Allahdad, the deceased, along with a few other, left their village and proceeded in a boat for cutting and collecting reeds on the bank of the river Indus. When they had travelled about a mile down stream, they saw Muhammad Hussain Shah, father of Wali Shah, bathing on the bank of the river. Muhammad Hussain Shah warned them against collecting reeds from the land belonging to him. But Allahdad, in spite of this protest, collected reeds from that land and started for the return journey. While they were returning with the bundle of reeds and sailing upstream in the river, one Ghulam Qasim Shah, nephew of Muhammad Shah, asked them to deliver him the reeds that were collected from his uncle's land. But the party refused to do so. He then caught the rope of the boat and pushed Allahdad and gave him a blow with a stick which was warded off by Allahdad. Allahdad then picked up a bamboo pole from the boat and struck Ghulam Qasim Shah. Ghulam Qasim Shah then shouted for help. It was then that Wali Shah and Mehboob Shah came up with loaded guns. On seeing them, Allahdad and his friend Hamidullah tried to run away, but they were prevented from doing so by Wali Shah and Mehboob Shah. Wali Shah fired at Hamidullah, who died almost instantaneously. Mehboob Shah fired at Allahdad, causing injuries to him. Wali Shah absconded and was never apprehended. Mehboob Shah and Ghulam Qasim Shah were tried under Section 302, read with Section 34 of the Indian Penal Code, that is Section 3, subsection 5, read with Section 103 of Bharatiya Nyaya Samhita for the murder of Allahdad. Mehboob Shah was sentenced by the trial court to 7 years rigorous imprisonment for attempt to murder. But on appeal, the Lahore High Court sentenced him to death under Section 302, read with Section 34 of the Indian Penal Code for committing murder of Allahdad, that is Section 103, read with Section 3 subsection 5 of Bharatiya Nyaya Samhita. Mehboob Shah appealed to the Privy Council against his conviction. The appeal was allowed by the Privy Council and conviction for murder was set aside. The following prospel were laid down by the court in this case. Under Section 34, that is Section 3 subsection 5 of the Bharatiya Nyaya Samhita, essence of liability to be found in the existence of common intention, animating the accused leading to the doing of a criminal act in furtherance of such intention. Number 2, to invoke the aid of Section 34 successfully, that is Section 3 subsection 5 of BNS successfully, it must be shown that the criminal act complained against was done by one of the accused persons in furtherance of common intention. If this is so, then the liability for the crime may be imposed on any one of the person in the same manner as if the acts were done by him alone. Third, common intention within the meaning of section 34 implies, that is, common intention within the meaning of section 3 subsection 5 of Bharatiya Nyaya Samhita implies a pre-arranged plan, and to convict the accused of an offence applying the section, it should be proved that the criminal act was done in concert pursuant to the pre-arranged plan. Fourth principle, it is difficult, if not impossible, to procure direct evidence to prove the intention of an individual. In most cases, it has to be inferred. In most cases, it has to be inferred from his act or conduct or other relevant circumstances of the case. Care must not be Care must be taken not to confuse same or similar intention with common intention. The partition which divides their bounds is often very thin. Nevertheless, the distinction is real and substantial, and if overlooked, will result in miscarriage of justice. The sixth principle, the inference of common intention within the meaning of the term under section 34 should never be reached unless it is a necessary inference deducible from the circumstances of the case. In the present case, in the opinion of their lordship, there was no evidence and there were no circumstances from which it could be inferred that Mehboob Shah, the appellant, acted in concert with Wali Shah in pursuance of a pre-arranged plan, when former alone with the latter rushed to the rescue of Ghulam Qasim. The two had the same intention, namely the intention to rescue Qasim Shah if need be by use of the guns, and that in carrying out this intention, Mahbub Shah picked out Hamidullah and Wali Shah, the deceased, that is Allah Dad, for dealing. But where is the evidence of common intention to commit the criminal act complained against in furtherance of the common intention? There was no case for convicting the appellant for murder. There was no evidence that appellant and Wali Shah ever entered into a premeditated concert to bring about the murder of Allah Dad in carrying out their intention of rescuing Qasim Shah. The principle enunciated by the Privy Council have been applied in a number of cases by the court in India. In a very important case, Ramnath versus State of Madhya Pradesh, one Sundar, the brief fact of the case is, one Sundar was attacked on a dark night on the public road by his enemies. He fired at him. There was no evidence as to who fired the fatal shot. The only evidence was the dying declaration of the deceased and some statements of neighboring residents, who said that all the four accused were seen on the road near Sundar. Ramnath was convicted by the High Court under Section 302, read with Section 34 of the Indian Penal Code, that is Section 3, subsection 5, read with Section 103 of Bharatiya Nyaya Samhita, for murder. The case was heard in appeal by the Supreme Court, which set aside the conviction of the appellant. Mahajan Justice observed, even if it is true that all the appellants were seen at the spot at the time of firing, this fact by itself could not be held enough to prove a common intention of the appellants to murder Sundar. It can well be that these four persons were standing together and one of them suddenly, seeing Sundar, fired at him. This possibility has not been eliminated by any evidence on the record. In such a situation, when it would not be known who fired the fatal shot, none of such persons could be convicted for murder under Section 302 read with Indian Penal Code or Section 103 of Bharatiya Nyaya Sanhita. It seems to us that in this case the High Court failed to appreciate the true effect of the decision of the Privy Council in Mehboob Shah versus Emperor and its judgment in regard to the applicability of Section 34 IPC has to be observed. Then after this common intention, that is requirement for the purpose of invoking the provision of section 3 subsection 5 of Bharatiya Nyaya Sanhita or section 34 of the Indian Penal Code is that the common intention, offense must be committed in furtherance of the common intention. And this common intention, either there is a pre-arranged plan or prior meeting of the mind, but the requirement is that the offense must have been committed in furtherance of the common intention, and that common intention not necessarily always be prior to the commission of the crime, and in many cases it was held that the common intention may develop on the spot. In certain situations, common intention may develop suddenly on the spot, and such common intention may be inferred from the facts and circumstances of the case and conduct of the accused. In a very important case decided by the Supreme Court in Rishi Dev Pandey versus State of Uttar Pradesh, the brief fact of the case is A and B, two brothers, were seen near the cot of the victim who was sleeping. One of them was armed with a garasa and other was with a lathi. Both of them were seen running away from the bedrooms of the victim. The victim died of an incised wound on the neck, which, according to medical evidence, was necessarily fatal. The court found that the two brothers shared the common intention to cause death. It was held that common intention may develop on the spot also, but where it is alleged that the common intention developed during fight, it must be established beyond reasonable doubt by the prosecution. Then the burden of proof with reference to the common intention to attract the application of section 34 of Indian Penal Code, that is section 3 subsection 5 of the Bharatiya Nyaya Sanhita, it must be established beyond any shadow of doubt that the criminal act was done by several persons in furtherance of common intention of all. In other words, the prosecution must prove facts to justify an inference that all the participants of the act had shared a common intention to commit the criminal act, which was finally committed but by one or more of the participants. Conviction of one and acquittal of others. That is to say, can a person alone be convicted by invoking the provision of section 3 subsection 5 of the Bharatiya Nyaya Sanhita or section 34 of the Indian Penal Code? Because we know that this joint liability or constructive liability, which is referred or provided under section 3 subsection 5 of Bharatiya Nyaya Sanhita, is that the offense criminal act must have been done by more than one person. If a criminal act is committed by more than one person, that at least two or more than two persons, then the question is whether conviction of only one person can stand good in law. The answer lies with conviction of one and acquittal of others in many cases. When two accused are prosecuted on the ground of benefit of doubt, the other accused cannot be convicted under section 302 simpliciter in the absence of proof of exact nature of injuries caused by each individual or each accused. Where a common intention is not proved, the prosecution must establish the exact nature of injuries caused by each accused, and more so when one of the accused has got the benefit of doubt. It cannot be postulated in such circumstances that the other accused alone caused all the injuries. Therefore, in such a case, the accused can only be convicted under section 325 instead of Section 302 of Indian Penal Code. But the accused could be convicted by application of Section 34, even if all his co-accused were acquitted, provided that there was a finding that the accused and others had committed the offense in furtherance of their common intention. In the case Bharward Mehpa Dona versus State of Bombay, the Supreme Court declared that the test of determining whether the remaining accused, one or more, could be convicted with the aid of Section 34, that is Section 3 subsection 5 of Bharatiya Nyaya Samhita, is that whether the remaining accused shared a common intention to commit a crime and participated in its commission. If on the evidence such intention and participation is established, the remaining accused could be convicted by application of Section 34. If after the acquittal of other accused, a single accused remains whose identity is clearly established, he can be convicted only when it is proved beyond reasonable doubt that he shared the common intention to commit the offense committed with some persons other than accused. Such other person may be named or unnamed by the prosecution. Effect of acquittal of one of co-accused. It was held by the Supreme Court in Y. Venkatayya versus State of Andhra Pradesh that even one of the co-accused is acquitted, that does not by itself absolve other co-accused of their conjoint liability of the crime. The law is that in spite of acquittal of one of co-accused, it is open to the court to convict the other on the basis of joint liability under Section 34 of IPC, that is Section 3 subsection 5 of Bharatiya Nyaya Samhita, if there is evidence against them of committing the offense in furtherance of common intention. Some offense, that is distinction between Section 3 subsection 5 and Section 190 of Bharatiya Nyaya Samhita, that is Section 34 and 149 of Indian Penal Code. Section 190 BNS, that every member of unlawful assembly guilty of an offense committed. Some offense must be committed by any member of an unlawful assembly, and such offense must have been committed in prosecution of the common object of the assembly, or must be such as the members of the assembly knew to be likely to be committed. If you are talking about the distinction between Section 3 subsection 5, that is a common intention, and Section 190 that deals with the common object, the corresponding section to Section 3 subsection 5 and Section 190 of BNS is Section 34 and 149 of IPC. Section 190 BNS, every member of unlawful assembly guilty of offense committed in prosecution of common object. The ingredient of the offense of this common object, some offense must be committed by any member of unlawful assembly, and such offense must have been committed in prosecution of the common object, that assembly. The scope of the section, that is Section 190. This section is divided into two parts, that is an offense committed by a member of unlawful assembly in prosecution of the common object of that assembly, and number two, an offense which the members of that assembly knew to be likely to be committed in prosecution of the common object. Offense committed by member of the unlawful assembly. The Supreme Court in Unus versus State of Madhya Pradesh held that presence of accused as part of the unlawful assembly is sufficient for conviction. The fact that accused was a member of unlawful assembly and his presence at the place of occurrence has not been disputed is sufficient to hold him guilty even if no overt act is imputed to him. Further, it was held in Mahmood versus State of Uttar Pradesh that once it is established that a person was a member of unlawful assembly, prosecution need not establish any specific overt act to any of the accused for fostering of liability. With the aid of Section 149 of Indian Penal Code or Section 190 of Bharatiya Nyaya Samhita. In a very important case, in case of Ram Dular Rai versus State of Bihar, it was held by the Supreme Court that mere presence in unlawful assembly cannot render a person liable unless he was actuated by a common object, and that object is one of those set out in section 141 of this Indian Penal Code, that is section 189 subsection 1 of the Bharatiya Nyaya Samhita. We will discuss that what is the common object and what is unlawful assembly. Common object is different from a common intention as it does not require prior consent and prior meeting of mind before a tax. It was held in Ramdullah Rai versus State of Bihar that a common object may be formed by express agreement after mutual consultation, but that is by no means necessary. It may be at any stage of all by all or a few members of the assembly, and the other members may just join and adopt it. Once formed, it need not continue to be the same. It may be modified or altered or abandoned at any stage. The expression in prosecution of common object is appearing in section 149 of Indian Penal Code or section 190 of Bharatiya Nyaya Samhita have to be strictly construed as equivalent to in order to attain the common object. It must be immediately connected with the common object by virtue of the nature of the object. There must be community of object, and the object may exist only up to a particular stage and not thereafter. Mere presence in an unlawful assembly cannot render a person liable unless he was actuated by common object, and that object is one of those set out in section 141 of Indian Penal Code, that is section 189 subsection 1 of Bharatiya Nyaya Samhita. Common object is different from a common intention as it does not require prior consent and common meeting of mind before time. It was also held that section 149 IPC applies when presence of the five or more than 5 persons is established, but only 4 are identified. Section 149 IPC does not require that all the 5 persons must be identified. Non-identification of some of the persons where presence of more than 5 persons is established does not in any way affect applicability of section 149 of Indian Penal Code or section 190 of the Bharatiya Nyaya Samhita. Then to understand this 190 of this Bharatiya Nyaya Samhita, it becomes imperative to know that what is an unlawful assembly. That is provided under section 189 subsection 1 of this Bharatiya Nyaya Samhita. That an assembly, what is unlawful assembly? An assembly of 5. An unlawful assembly is an assembly of 5 or more persons if their common object is number 1 to overawe by criminal force the central government, B. the state government, C. the legislature, and the next any public servant in the exercise of lawful power. Number 2. To resist if the common object of that assembly is to resist the execution of law or legal process. If the common object of that very unlawful assembly is to commit mischief, criminal trespass, or any other offense. Next, if the common object of the unlawful assembly is by criminal force to take or obtain possession of any other property, or to deprive any person of any corporeal rights, or to enforce any right or supposed right. The next is number 5, by criminal force or to compel any person to do what he is not legally bound to do, or to omit what he is legally entitled to do. What is 5 or more than 5 persons? To constitute an unlawful assembly, there must be more than 4 persons, that is 5 or more persons. They must share the common object of others, where more than 5 are prosecuted for writing, but some of them are acquitted, and those who are convicted are less than 5 in numbers. The conviction is illegal. Common object, the essence of an unlawful assembly is the common object of the persons forming assembly. The object must be common to all those persons who constitute the assembly. That is, they should all be aware, section Mere presence in an assembly does not make a person member of an unlawful assembly unless it is shown that he had done something or omitted to do something which would make him a member of the unlawful assembly, or unless, being aware of the facts that an assembly is unlawful, one intentionally joins the assembly or continues to be its member. An assembly of 5 or more persons cannot be called an unlawful assembly if its object is to be defend property by the use of force within the limit prescribed by law, that is, right of private defense of property. Then we have to see what is the difference between common intention and common object as is provided under section 3 subsection 5 and section 190 of the Bharatiya Nyaya Sanhita. The basis of liability under section 3 subsection 5 is the existence of common intention animating the accused. Liability under section 190 is based on the existence of common object or knowledge of the probability of the commission person of the offense, that is, natural consequences as the accused knew to be likely to be committed. Under this section 3 subsection 5, common intention within the meaning of section 3 subsection 5 is undefined and unlimited. Common object is defined and is limited to the 5 unlawful objects stated in section 199 of the Sanhita. Limited to the 5 unlawful objects stated in 199 of the Sanhita. Number 3. Criminal act under section 3 subsection 5 must be done in furtherance of common intention. But the criminal act under the common object, that is under section 190 of Bharatiya Nyaya Sanhita, must be done in pursuance of the common object, or it would be sufficient if the members of the unlawful assembly knew that offense was likely to be committed. Fourth, some act, howsoever small or insignificant, must be done by every person accused of the commission of a crime is not necessary under section 3 subsection 5. Merely membership of the unlawful assembly at the time of the commission of crime would be sufficient for application of section 190. Active participation under section 3 subsection 5 is unnecessary. Some act, howsoever small, must be done by every accused. In section 190, mere membership of the unlawful assembly at the time of the crime is sufficient. Active participation is not necessary. In common intention, offense must be committed by 2 or more than 2 persons. In common object, offense must be committed by 5 or more persons, as only then an unlawful assembly exists. Section 3 subsection 5 enunciates the principle of joint liability but creates no specific offense. It is simply an interpretive in character. In section 190, that is common object, creates a specific offense declaratory of the principle of joint liability. In section 3 subsection 5, emphasis is individual are divided between the group's act and the individual's mental state. In common object section 190, emphasis is entirely on the unlawful assembly as a group, both physically and mentally. That is individual role. With reference to section 3 subsection 5, the individual offender is associated physically and mentally with the criminal act, a sharer in both act and intention. With reference to common object, an individual is punishable merely by a member of unlawful assembly at the time of the offense, even if he did commit no offense.